It's sort of fascinating, isn't it, when the courts pull rank and where it's in the courtroom, not the campaign trail, that's the principal battleground for Donald Trump's second term ambitions. In a double blow to his presidency, federal judges have blocked two cornerstone policies: the termination of humanitarian parole programs and the imposition of sweeping new global tariffs under emergency powers. These rulings are not merely technical corrections, they are constitutional clarifications, rebuke to the idea that the executive branch may rule by fiat. So, beginning with the tariffs, on April the 2nd, Trump invoked the 1977 International Emergency Economic Powers Act, the IEEPA, to declare a national emergency based on America's persistent trade deficits. And the justification that this imbalance, coupled with issues such as the drug trade across the southern border, posed an unusual and extraordinary threat to national security. Under this pretext, he imposed a baseline 10% tariff on most imports, with reciprocal tariffs of up to 50% on countries running a trade surplus with the United States. It was, he claimed, a necessary assertion of sovereignty. But a three-judge panel at the U.S. Court of International Trade in Manhattan has now disagreed firmly, emphatically. And in their ruling, the judges found that Trump's use of IEEPA to reshape global commerce was not only unlawful but unconstitutional. Congress, they noted, holds the exclusive power to regulate international trade, and to read the IEEPA as granting the president unlimited authority would be, in their words, an improper abdication of legislative power. And they rejected the administration's Nixonian historical precedent, tariffs invoked in 1971 under the Trading with the Enemy Act, as irrelevant to the statutory limits of the IEEPA. Trump's attempt to shoehorn modern tariff policy into an emergency framework designed for sanctions against hostile foreign actors was, quite literally, judged to be an abuse of language and law. Brilliant. Brilliant, isn't it? This ruling invalidates Trump's Liberation Day tariffs in one stroke. These tariffs, which had already rattled global markets, strained US-EU and US-China relations, and endangered American importers, particularly small businesses and publicly funded institutions. On the same day, Judge Indira Talwani, sitting in federal court in Boston, struck down another Trump edict: his administration's suspension of parole programs for migrants from countries such as Ukraine, Afghanistan, and Venezuela. Parole in US immigration law allows the government to temporarily admit individuals for urgent humanitarian reasons. And the Biden-era policy granted such access to thousands fleeing war, persecution, and political instability. Trump's administration, in one of its first acts on returning to office, ordered these programs to be paused and dismantled, and Judge Talwani ruled that such a sweeping directive was illegal. Parole, she reminded the administration, must be exercised on a case-by-case basis, and suspending entire categories, especially without due process, violated both federal statute and constitutional protection. Her decision reinstates protections for thousands, including Afghans who served alongside US forces, Ukrainians fleeing Russian aggression, and Central American families seeking reunification. It also certifies a broad class of affected individuals, effectively blocking Trump from conducting mass deportations under this guise. These decisions strike at a central tension in modern government, where does executive discretion and legislative oversight begin? Trump's strategy has often relied on declaring emergencies to justify maximalist policy swings, be it tariffs, immigration restrictions, or pandemic measures. The courts have now set a clear boundary. Emergencies are not rhetorical devices. They require demonstrable, extraordinary threats, not just political urgency. And these rulings reassert the idea that the presidency is not a roving lawmaking institution. That is the role of Congress. The Trump administration's argument that unelected judges should not interfere is itself a misunderstanding of the American Constitution as well. Judicial review exists precisely to prevent arbitrary rule. As Senator Ron Wyden has said, Trump's trade taxes jacked up prices on groceries and cars, wrecked supply chains, and mangled the Constitution, and the courts now appear to agree. So, where does this leave Trump? His tariff war is in legal limbo. His immigration crackdown is enjoined, and the courts have reasserted constitutional order. This is not merely a pause in his program, it's a reminder that power must answer to law. Even presidents, especially presidents, are not above the law.